Whoa. What's up, guys? Welcome to the Transparency. Good morning. Friday. Let's do this. Hello to all the mods, members, subscribers.
Listen, folks, I know there's a history here.
Oh, there's a fucking history here.
I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
What is up, mod squad? It's a snow day here in lovely Ohio.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah, I've been drinking or anything, right?
No.
Okay. Drive careful, okay?
Thank you.
This is with the other group that ran away.
Oh, really?
They just ditched it.
Awesome.
Yeah, those ones kept walking in the car. The other ones.
It's truly for the win.
For the win there. Like a -9. I was just at the airport. All right, guys. Let's talk about it. Adding to the stage here. Karen Reed had a big hearing yesterday, just like Richard Allen did.
Pursuant to statutory.
Look at this gem right here. He looks so happy to be there. I do want to say that he looks just so. He looks like just a happy guy, man. Again, welcome to the Transparency. Let's do this. Let's talk about Karen Reed. Here was the hearing yesterday.
Pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order impoundment was appropriate. Pursuant to the case law, I would ask that the motion be allowed.
All right, and just so we're clear, because you referenced it, I did receive, as you're all aware,
Fuck you, Beverly.
correspondence
Fuck you.
from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. So with that, I'll hear from you now, Mr. Yannetti.
I appreciate that. Thank you, Your Honor. May it please the court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order,
just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes
I haven't
no
seen
sense
those letters.
in this case. And with your permission, I'd like to divide my argument on this issue into 2 parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case.
All right, so
Because the content-
which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are.
Right, so I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right, how about the second part of your argument? Would you be arguing them as well? Nobody provided them to me?
Whose
Well,
job?
this is the Commonwealth's motion, Your Honor.
Yeah, and your opposition, and I don't have from anyone. So
Your opposition.
how about
I mean,
the second part of your argument, Mr. Yannetti?
this is fucking just
Well,
awful.
it does touch on that, Judge. You know, the Commonwealth has revealed some of the contents of some of the letters, but I need to point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Yes, Your Honor.
If you're just going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
He was supposed to put them in with the motion if he wanted them to be sealed. I don't believe that they were put in with the motion. He just asked for them to be sealed, if I remember correctly. And then only reason I'm going to fast forward is because we literally watch her read to herself and scan these letters. So for judicial economy here, Atlanta's courtroom, we're going to fast forward.
I'm going to reference them in terms of a subject matter, but not the details.
This is supposed to go to trial in March. I'm sorry.
So the letter dated August 3rd, 2023.
I like your hat.
Do you have that in front of you, Mr. Yannetti?
Like,
I do, Your Honor.
All right, so the second paragraph, the second full paragraph,
you will not be saying
I'm not
that.
going to allow you to reference that right now.
Okay. Sounds
Your Honor,
fair.
if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can see
see
it.
the light can see through it. I've got the print facing me.
You could see a portion of the print, that's all, just from
Okay.
the angle.
All right, thank you.
She wants
All right,
to argue
so
everything.
with those parameters, Mr. Yannetti, I will let you reference the subject matter of the others.
Okay, that's fine, Your Honor. So in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the subject, not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is, it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date.
Boom.
And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today.
8 letters.
The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that.
He knew.
Even before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reeve defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions.
The genie.
My client is entitled under
Hell
the
yeah.
Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right, is there a response from the Commonwealth or no?
No, Your Honor.
Okay. All right, so I'll take this under advisement.
Best
I do
part,
need copies
we have
of
nothing to
these
say.
letters, so if Mr. McDermott can make copies and then hand them back to the Commonwealth.
We have nothing to say.
All right, so the second motion is the Commonwealth's motion for Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir.
God bless this man.
Hi, you can stand at the podium or council table, wherever you're comfortable.
I hope he wins.
In a minute, I'm going to ask you your name. I'm going to hear from you, but I do just want to state that I appreciate that today I did receive a response from Boston Magazine. I received there's a memorandum, there's a limited opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity to read it a short time before the hearing. But I do appreciate the response, and more importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, ERTSCHE.
Okay. All right. Could you tell?
Representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right, so there is the Commonwealth filed a Rule 17 motion. You as the third party or the record holder have a right to be heard, so I'll hear you.
Thank you, Your Honor. There are really three documents at issue. Two recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you explain that, please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is an interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2,
Okay.
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And and she says, that these are, she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a gold mine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape. Body language, physical reaction to a question, the same thing. These being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, the case that ultimately, when it went to the Supreme Court, became Bransford v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the US Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 6.
Just so everybody knows, this guy is oral arguing on the behalf of Voss, who was with the Boston Globe. She has suffered immense harassment from this case due to her, I would say, unbiased reporting. She's given both sides, and she's the one that interviewed Karen Reed, did a couple of those, and basically what Lally and the state wants is all of her shit. So that's what this man's doing here, is he's oral arguing on the fact that she's a journalist and she has rights to, I mean, you have these 2 interviews, go ahead, do whatever you want with them. They want all of her off the record stuff, whatever statements that she would have made. And he makes a great statement when he says, I think the Boston Globe would have reported if Karen Reed admitted to the crime. There you go, Boston Magazine, not Globe. There you go. It was just priceless. So,
A subpoena issued to a reporter by defense counsel in a murder case. So those 2 cases, I'd say, are exactly on point. Now, here, Ms. has to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the 2 recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that 3rd interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out in her affidavit. Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the 4th estate. Now, there's an additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. In petition for the promulgation of rules 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that's binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio-recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour, the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction
Yes.
needed. I'm not quite sure how that gets conducted.
Okay.
But within 2 weeks,
Okay,
possibly less if necessary.
all right. All right, I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor. The
I got something to
nature
say.
of the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I would refer the court to the decisions
Everything
that are
you've done
cited
is
by
speculative.
counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking about a confidential source, we're talking about potentially confidential information. But notably, what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion in submissions that there is not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements, the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. Through 2 of these 3 interviews, she's present with her attorneys, who presumably know.
She's allowed to talk. She can say whatever the fuck she wants.
And yet she makes these statements voluntarily.
She surely
to these interviews
sure did.
voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant.
They're all
makes
out
them
there.
admissible. And that is why the Commonwealth is specifically requesting those
God, I
items.
hope the notes say "Go fuck yourself, Lally."
As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17 when asked that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss I what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that third. I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first two recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
What do you say about that, Mr. Bershon?
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said because the Ms. Voss does not
I don't think
propose the release of the two interviews, save the off-the-record portion from the lawyer.
I think he's talking about the third interview.
Yes, but I
don't think you heard what I said. That was awesome.
Part of the first two interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena.
I can't. This guy talks so soft. Sorry.
Ms. Reed and not of anyone else, not from.
I will say this. I went ahead and took all of the data and made a very extensive Excel spreadsheet. I put it out there, and based off of my personal investigation into the digital movements of John O Keefe's phone, I think I single-handedly proved that his phone was being passed around, not by Karen Reed, but in fact by Jen McCabe and the other, what I believe, actors of that evening, going into the early morning hours of, what was it, January 29th or something. I do believe that Karen Reed is factually innocent. She's innocent until proven guilty. I don't believe this is going to court, unfortunately, because I wanted to see this. I believe that the feds are going to blow it in terms of their investigation. They're going to make it in good faith. They said that they cannot let Karen Reed go to trial with what they have, with what they possess. And that would mean it's exculpatory. I don't believe that you're going to come out and say that in a conference call. I don't believe that both sides are hearing this. But what's going to in my opinion, happen before the end of the year is Karen Reed is going to be released. Different arrests are going to happen, and these sanctions. I once Karen Reed is okay, let go and off the hook of this. When I say release, she's out, but I mean like release of these charges. There is a guy by the name of Mr. O'Keefe who was a police officer. So when people want to say, "Oh, Lana, you hate police officers," or this, that, other, I laugh at that. No, because the next step is that Mr. O'Keefe was murdered. So what are we going to do about that? And I think that that's going to be the focal point there, is to see that Mr. O'Keefe gets justice, and his family, and his niece and nephew that he ends up adopting and trying to raise as his own. So, but this 2024 year in Boston, in this area, is going to be, whoa, this is unprecedented in my opinion. And I think the feds need a win underneath their belts. They've shaky. Here's their opportunity to get some notches back up with public opinion. It matters. So, because I think they're going to take some notch. I think they're going to take some hits in the Brian Kohlberger case. So they're going to. Everything's unfortunately that just. It's a chess game. It's a checkers game, whatever people want to call it. But for the feds to come out and go ahead, and they're going to release their investigation here in the next week or two. And Gannetti and Alan Jackson are going to be using that report. They're going to make a comment here about it at the end. And I want you guys to really, really listen to it. I'm pumped for Karen Reed. It pisses me off to see that someone like Jen Coffeneffer, who's a female, talking the way that she is. Like, this is bullshit. If anything, Miss Coffeneffer should know you're innocent until proven guilty. And if, with all the evidence that's out there, to sit here and literally say that you think that John O Keefe suffered those type of wounds to what they're saying is just fucking laughable. And if it's not if you don't laugh about it, you would cry about it. That's what I mean by that. And I think that anybody that had a part in this, and if you're a police officer, you should be fucking irate. So where's all the fucking cops going? No one's going nuts. Why aren't there any cops down there going fucking nuts in the Boston PD? I think that that's bullshit. You know, if anything ever happened to like me or my teammates when we would have been in college, like everybody would have rallied around us. Where the fuck are the cops trying to rally around for justice for one of their own? And I want to see that. I want to see people having Mr. O'Keefe's back that are, you know, wearing the uniform. That's what I want to see. And I haven't seen it yet. And until I see it, then I'll shut up about it. But the fuck out there, you know, get out there and be one of the people that are on the steps. Be out there in uniform. Come on, man. This is ridiculous. But how it looks in the evidence is that 100% cops covered up, and for whatever had happened that night, covered up what truly happened to Mr. O'Keefe. And that's one of their own, taking out and covering for what, family. So once this is all going to pop here in the next week or two, then the next thing I do see arrests coming, because whatever the feds have, it is good enough to, I believe, you're now subject to, I mean, this is a federal investigation. And I know that I think Turtle Boy has like 90 days from the time he was arrested to still be behind bars, because that was part of the conditions of him being out, is that if he was picked up on different charges, and he would be forfeiting that, and then he'd be behind bars for like 90 days. So, but Karen Reed, I mean, there's nothing that can bring back John O'Keefe. So I think the first thing to do is to make sure that Karen Reed, her life is, you know, where it needs to be and protected. And then once that's all settled, then they can go work on that civilly. But then the next step's going to be is going and getting justice for true justice for John O Keefe. And I think that anybody that had a part in this, and I think that this guy shouldn't have a fucking job anymore. Not this guy, Lally. Get him the fuck out of there. Fucking the guy that's prosecuting Turtle Boy, get him the fuck out of there. He can't even oral argue. And I just think it's hilarious that people want to talk about how I am in a courtroom. At least I'm passionate. I'm a victim, and I had a face, and do all that. So fuck yeah, there's gonna be emotion, and I'm proud of my emotions. Get the fuck up out of here, you lying cunts. That's how I feel about it. And we'll see what happens. But yeah, his ass is grass. I'm trying not to say certain names because I feel like when you say certain names, then your channel gets like, ooh, Lana said that name and now we're going to do this. But you know what I also saw last night? Before I talk about things, I educate myself. Otherwise, I'd be a fool. How do you talk about something where you have no education behind it? You have no substance. How can you literally talk about something online in a forum? So I went back and I wanted to watch December 22nd's hearing that Turtle Boy had. And I think I'm going to play it after this because, that's a quarter Lana. Yep, cussing. Because you know what blew my mind? This fucker thought that he could really tell the judge, I want you to get the judge is like, what do you want me to do? Literally, this guy was asking as a prosecutor to infringe upon somebody's literally, like, you cannot, somebody has to do something in order for you to then make a move. You cannot prevent somebody from saying something. It's once they say something, that's when you can do something. This cocksucker thought he could get literally up on a podium and as representing at the superior level, he could literally try to say that, hey, I want you to put provisions on this man's speech. Wait, excuse me? You think I could tell him that he can't say certain people's names? Have you lost your fucking minds? That's why I laugh when people are like, you can't say so-and-so's name. Oh my God, you can't say their name. They have a protection order against you. Well, then you must be sorely mistaken on what you think a protection order is for. A protection order is not to protect, it's not to prevent somebody from saying your name, saying your fucking name. I could not believe, like, when you truly, like, break it on down, what this lawyer of how many fucking years is saying in court. Speaking of court, it took a magistrate, I think 30 days to issue a decision in my latest attempt to stop people conspiring against me and stop menacing my life. 30 days it took this magistrate to make a decision. That's a long fucking time, right? It took the superiors up in Indiana 3 hours and 45 minutes to fucking say, Gull, you done it wrong. Here you go, Alan. Here's your fucking, here's your team back. And I'm over here like, you couldn't have sucked that bad if it took somebody 30 fucking days to make a decision. So that's my rant for today. It's just to say, like, let's see. I've never claimed to be a lawyer, but I do claim, and I'll always claim this, I do believe that I'm one of the best criminal researchers when it comes to discoveries in the country. I will take my God-given abilities over any discovery, not over people. Give me the discovery and I'll tell you what the fuck's up, because I would want, justice. And it's not to, so yeah, I think I'm one of the best criminal researchers with discoveries in the country. I'll take any discovery on. I'll find what it is that you need, and I'll also tell you if it's there, if it's not there, or other things that could come up or whatever, especially with the timeline. But I've never claimed to be a lawyer, but I've also never claimed to be a fucking pussy. So I don't need anybody to do my dirty work. I don't need anybody to fucking speak for me. And I handle my business, not in the streets. You fuck with my life, I go and I seek relief where it should be seeked. But to see this type of shit, fuck, I'm nailing it. That's how I feel.
Counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize a common law privilege. They do. They recognize an evolving privilege that's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C.
Exactly, Mod Squad. And guess what these people fucking totally forgot? They totally forgot about the word appeal and what it means in the state of Ohio. Oh, fuck with the best, baby. Come on now.
And it's true. We're not saying that the Commonwealth...
Read the findings.
Right.
If you find somebody credible, but then on appeal you can show that they're not credible, it takes the findings.
Continue to suffer.
I'm taking it to district.
That her role becomes large. And
be right back.
Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay. Thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in. And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me, I am concerned about the safety of the reporter.
You should be fucking concerned.
To suffer harassment or any danger as a result of this.
Oh my God.
So
did she take some fucking Xanax? What the Oxy? What did she take before she fucking took to the bench today? Maybe she was like the way that she is because Alan Jackson wasn't in the room, because I think this broad can't handle Alan Jackson. I think that Alan Jackson really makes the Boston folks walk a little differently. Not that I don't think United can handle this himself, but Alan Jackson has he's literally conducting an orchestra in the courtroom, and he knows what's going to happen before it happens. Just like Jose Baez, I think Alan Jackson is one of the most prepared attorneys, litigators, in terms of the material. He has it. He goes and gets it, and it's just Benzo Bev. Oh my God. I'm dead. Holy fucking shit. Oh my God. H-Bag. See, that's why I need you in these fucking lives. Give a shout out to my girl K Miller in the house buying 20 for y'all. 20 memberships. You get a membership. You get a membership. Y'all get a motherfucking membership. I mean, you have really good odds here with 262 people. 20 people. Guess what I just found out? I don't even know if you have to be watching the live to realize that you got a membership. You could just get one. You know what the best part is when people get the memberships that are fucking lurking and you see their names pop up and you're like, I knew you watched me. I knew you were a member already. I just love that shit. Oh, you say you fucking hate me, but all you do is these people, they be snorting, Lana. Fucking crazies. I don't know why they just don't go out there and live their lives. I don't know. I guess they just want to live through me. I guess I got it pretty good like that. I've always been a good time. I love the lurking memberships. I swear, I think that's why Kay Miller does it. I think she does it like that on purpose. I think she's like, let's see who's watching Atlanta today. Kay Miller, how you been doing? Actually, tonight it's going down. I know you guys have been waiting to see all the stuff that myself and Bella did in Moscow and Pullman and Bonners and Sandpoint and Coeur d'Alene. Literally, I just want to say thank you to the people that were out there with me. They know who they are, and we fucking rocked it. We killed it. I couldn't have asked for a better trip. And what I mean by that is I have exculpatory evidence for Dr. Moore and his family. I believe I had it even before the trip, but I don't think there's a greater feeling as to be able to look somebody in the eyes and say, here you go. I hope this helps. I hope this helps. And I think it will help. And the shit that's going to come from that trip, you guys think that what's happening here to Karen Reed, it happens all the time. And it's starting to become more exposed. Honestly, I think it's because of people like me. I think it's because of other people that do this. But you have all eyes on you, and now there's other ways to get the information out and things like that. So the word conspiracy, guys, by itself, it's a crime. Even if nothing comes of it, if you were conspiring to do something, and then even if you didn't fucking do it, you can still be like that. That's a charge. It's a criminal charge, even if nothing happens. So, but I'm excited to share it with you guys. Thank you for that. And there are people out in Idaho just like Karen Reed, literally did nothing. And for whatever reason, Dr. Moore was sought out. And I think it'll come out, but I'll let that happen when it happens. But when you have the wrong motive for a crime, then everything goes the other way. If your motive isn't right, then your investigation doesn't make any sense, your timelines and stuff like that. So the motive, just like in the Karen Reed case, what was the motive? Karen Reed and her boyfriend were arguing. That's not what any of the witnesses said at any point in time leading up into that point of the night. So that would be like not the correct motive. What was the motive? So when you get the motive wrong, you get the perp wrong. So same thing could be said with the Idaho 4 case. What's the motive? Oh, he was some stalker, crazy, deranged motherfucker came from Pennsylvania to Idaho where the death penalty. But if the motive's wrong in the case, then Brian Koberger looks less and less like the person that could have done this, right? So we all need to pay attention to motive. And I know that it doesn't, what do they try to say? We don't have to, it's not part of the elements that we have to prove as, the prosecution. But logically, it should matter to any juror. Why in the hell would this person kill this person? That should matter to you. And it may not be an element, but it's very important. And I think a good criminal defense attorney talks about motive.
It's February 1st, which is 2 weeks from today. Is that doable? That's doable.
Okay. All right. Thank you. So, Mr. Yannetti, we need to get a date for the remaining 2 motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks.
Trial that's going to go in a few weeks. Has she lost her fucking mind? Just kidding. You guys, there's a lot of things that I can and can't handle. This broad, God bless Bev, Benzo Bev. You heard it here first by H-Bag. I don't want to we need some serious merch over here. We got Benzo Bev right across the titties. We got on the back, I'm just here for a noise complaint. Y'all can just, I don't know, gang bang it up. This is just wild. We have a trial that's here in just at the beginning of March. They don't even have DNA results back. They don't even I can't. I just can't. I can't with this. Yeah, this is Tina with What the Fuck Translation Services. Absolutely. This is definitely one of those moments. Benzo Bev. I just personally think it's not Benzo's. I think that when Alan Jackson was in the courtroom, she probably was just like, oh my God, I don't have traveler's colon. I can just take a nice shit here and I'll be fine. That's what I think. I think Bev has traveler's colon when Alan Jackson comes to town. And she's just so tight. But again, this shit is wild. I don't know what planet these people live on, but it ain't Earth. It's just not. I mean, I gotta shake my head, We have a trial that starts here in just a couple weeks. We got the feds. They're about to blow this out of the water, Bev. And I just hope to God that you ain't part of it. Okay, girl. But Deborah says, "Oh, Deborah Dixon, are you sure you're not DeBoer Bix? I believe Karen Reed is guilty." Well, by the U.S. Constitution, everybody is innocent and so proven guilty. I hope to God you don't live in the United States of America, because I would like to ask you one thing, and that would be, do you not believe in our U.S. justice system, that you are innocent and so proven guilty? And also what I would say is, why do you believe Karen Reed is guilty? We let, all walks and beliefs, everything's welcome here. But what I always ask for is why? If I'm going to make a statement like that, why? You don't just believe something because you just wake up in the morning and you're like, I'm going to be a Michigan fan this morning, but I'm really a Michigan State fan. I mean, come on. So why would you say that you believe Karen Reed is guilty? And I hope your answer is Jennifer Coffindaffer. That would just make my fucking day. Jennifer Coffindaffer. Her own feds are blowing up her spot, man. And she's like, well, your feds went in there and guess what they just pulled out? They just pulled a rabbit out of the hat. Yeah. But hey, again, we don't block people here unless you attack. Hungry like the wolf. Speaking of which, I guess it's Stalker Awareness Month. Did you guys know I love true crime and I love trivia? I'm gonna tell you guys something about trivia. Did you guys know that I believe there are some music artists out there that have a legit fucking bitch and complain for civil? They have some, I think they can go civil on some people. Can you believe that the song by Enrique Iglesias called Escape? Man, what a day. All right, guys, you guys rock. We'll see you on the next one. I think it's at 3 p.m. Check me out. Over and out. Now I know why Ellen danced all the time of her show, because of all those difficult episodes, man. She had to have the dancing in there. That I was given to. So there was 2 different discs. Okay? They all knew about it.
Okay, yeah. But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there?
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna be in trouble.